You're 6 months out of your crash. You've been to the ER, you've been to physical therapy, and you've missed days at work. And every time you call the insurance company, you get the same answer. We're still reviewing your claim. Someone told you that these cases, they settle fast. So what's going on here? Here's what's happening. The insurance company, well, they're not confused, they're not backed up, they're just following their process. Specifically designed for you to settle for less or walk away before you know what your case is actually worth. I'm Dia Asthana, managing partner at Caldwell Wenzel Asthana, personal injury lawyers. In the next few minutes, I will walk you through every phase of this process, what the insurance company is doing at each stage, and the decisions that determine whether you walk away with nothing or a fair result. Alabama is an at-fault state. The driver that caused your crash is legally responsible for all of your damages. But legally responsible does not mean that they pay right now. Their insurance pays at the end of the case, whether that's a settlement or a jury verdict. That could be months or years away. In the meantime, your medical providers, well, they don't wait. Bills come due and unpaid bills can go to collections. And that gap between the crash and the settlement is where cases can be built in value or broken. A realistic timeline for a minor injury is about 3 to 6 months. Moderate injuries with a little bit more extended treatment could range between 6 to 18 months. And more serious injuries or disputed fault cases can take longer, a year to 3 years, or sometimes even more. The most common mistake that people make is trying to compress that timeline before they even know what the case is worth. And that decision cannot be reversed. So here's a scenario that I see more than anything else. Someone gets hurt, they treat for a few weeks, and here's the insurance company with an offer. The person is exhausted, behind on bills, so they accept. 3 months later, those minor injuries become more serious, and now they need a surgery. But the insurance company says, you settled, we don't owe you anything else. That decision is permanent, and there is no appeal. So here's what happens. In personal injury law, there is a concept called maximum medical improvement, or MMI. This is the point where your treating physician can say with confidence that you have improved as much as you can medically, and here is what care looks going forward. No experienced personal injury attorney sends a demand letter before you have reached MMI, because until you reach it, you have no idea of the full extent of your injuries and the value that you are owed on your case. You don't know if you need surgery or if you will have any permanent limitations. So how long does MMI take? A soft tissue injury may stabilize within 3 to 8 weeks. A herniated disc requiring surgery may take a year or more. And a traumatic brain injury can take longer still. And here's the trick. The insurance company, they know your treatment is not finished. That is why they make that offer early, before you know the value of your case, the extent of your injuries, and when you're most financially vulnerable. So the right move here is to not touch that offer until your doctor has cleared you and your lawyer has had a chance to review your complete file. Patience during this stage is one of the most financially protective things you can do in your case. Once your attorney sends the demand letter, the insurance company responds usually between 30 and 60 days, and that response looks something like this. We have reviewed the records very carefully and do not see the documents to support a high offer. That sentence is designed to sound final, but it isn't. What it's actually saying is that we have found gaps in your file and we're going to use them against you. Every adjuster has an authority range to make an offer without the approval of their supervisor. Their first offer will always be low. That's because the adjusters know that most people will accept that low offer given their financially vulnerable position. Any gaps in documentation, well, they will definitely use that as ammo. Gaps in medical treatment, incomplete wage records, missing medical bills, or a prior injury that they can point to. All of these are preventable, but only if documentation is thorough and starts from day one. And here's the factor that most people don't know about. Insurance adjusters, they know and track which firms are trial firms, where they take cases to trial, and which ones don't. A firm that has a track history for settling for low amounts will always get low offers because there's no consequence to the insurance company for lowballing. A firm with a real trial record, they get treated differently. The threat of a trial is only real if in fact it's real. There's one Alabama law that I need y'all to know about because the insurance company is counting on you not knowing it. Alabama follows pure contributory negligence, and only a few states in US use this rule. If you're found even 1% at fault in causing an accident, your claim may be completely barred. Let me repeat, not reduced in value, barred. This is exactly why insurance companies will reach out to you immediately to get recorded statements. It may look like they're processing your claim, but what they're actually trying to get is any evidence or fact from you that shows that you were partially at fault. I didn't see them coming, or maybe I was going too fast. Well, these two sentences can really gut your case in Alabama. So before agreeing to give a recorded statement, make sure that you have discussed the facts with a lawyer. But if the insurance company calls you and asks for a recorded statement, you can always tell them that I'm happy to talk to you about the damage to my vehicle, but with respect to my injuries, I'm still unsure as to the full extent of those, and I am also considering hiring a lawyer. I would then recommend that you go speak to a lawyer. The consultations are usually free. One exception is if the other driver was acting with wantonness. Drunk driving, driving under the influence of drugs, street racing, or acting in a reckless manner are all exceptions to contributory negligence. So, contributory negligence may not apply, and you may be entitled to punitive damages. But that is the exception. For most cases, contributory negligence is the sharpest tool that an insurance company has. Now, if the negotiation does not produce a fair result, filing a lawsuit may be your only option. But I would like to clear a common misconception. Filing a lawsuit does not mean that your case is going to trial. Most cases that get filed still settle before a jury hears them. But filing a lawsuit changes everything. It puts the case on a court timeline. It forces the insurance company to now retain their own lawyer. And it signals credibility that we are prepared to go all the way. Now, the hard deadline. In Alabama, you have 2 years from the date of your accident to file a personal injury lawsuit. If you miss it, you can no longer make any recovery on your case. 2 years will go by faster than you think. 6 months of treating, a year spent negotiating with the insurance company. All of a sudden, you find yourself at month 22 and the clock, it's almost run out. One more thing, if your accident was caused by a city-owned vehicle or a municipality vehicle, that notice deadline is down to 6 months, not 2 years. If that's your situation, you need an attorney yesterday. There are 4 decisions that you make which can significantly reduce what your case is worth. And most of them are made in the first few weeks. The first one is you agree to give a recorded statement. And in that statement, you unintentionally admit partial fault. What the right thing to say there is, I'll have my attorney look into this. The second decision is that you choose to delay treatment. You delayed getting treatment to begin with. When you started getting treatment, there were gaps in that treatment. You didn't go to all the doctor's appointments. Well, what does that show the insurance company? That you are not that hurt. The third decision is to accept the first settlement offer. We've done a video on specifically this topic. The first offer never reflects the true value of your case. So before accepting it, get a consultation with an injury lawyer. The fourth decision is to take what the at-fault driver's insurance company offers you and stop there. You forgot to take a look at your own insurance coverage under what's called UIM or UM, underinsured motorist coverage or uninsured motorist coverage. That is a benefit that can get you more money for your auto accident case. And most people don't know that they have this benefit until it's too late. So, how long does an Alabama car accident settlement take? As long as it takes to do it right. The only thing more expensive than a slow settlement is a fast one that doesn't reflect what you went through and what your case is really worth. If you're in this process now, or you have been given an offer that you're not sure is fair, call us now before you sign anything. We offer free consultations and there is no charge unless we win the case for you. Call 251-444-7000 or click the website link listed below. We have offices in Alabama, in Mobile, Birmingham, and Foley, and in Pensacola, Florida as well. And if for some reason you cannot come to us, we are more than happy to come to you. Don't forget to like this video and subscribe so that you don't miss our next video on the top 5 things that can destroy your Alabama car accident case. Thank you for watching.